Hey guys, it's Kathy. I hope you're doing well. I'm coming. I just need one more second. I'm having issues here. I'm having lots of green screen. So I got my pity. I got a new green screen and all the black you see, I can't get rid of it because the light does not hit it. So I shoved it. I have it taped to the wall. I have it shoved up as far as it can go. I gave myself a whole bunch more room. So the green screen goes way back now. Well, the light doesn't hit it. So now I have to go get some more lights. But I work a double today. So it's gonna be like this tomorrow. What? Sorry, I just saw something. Of words. Oh, I thought I saw something else in chat. We get to the verdict today. Finally, we get to the verdict day. So here are the charges. Are you ready? Domestic violence, resisting arrest, and I don't criminal misconduct, I think. I think criminal misconduct, but I could be wrong. All right. So all we have left are the closing statements. So out of domestic violence, resisting arrest, and criminal misconduct, guilty or innocent of any of those charges, what do you think? What do you think the jury's going to say? It's a jury trial. The judge doesn't get to say. Thank you. Yeah, lots of things hate me right now, Sue. I am with you. You and me are besties. He was up to a lot of shenanigans. Nope, that's not an answer. Not guilty on everything. That's me. You know who I am? You don't know who I am. I know the mayor. Hey, no parking lot fights. No. Hawaii is so expensive. It is so expensive. Elvis, it was a misunderstanding. All right, let's get to this. Let's get to this.
Thank you. Please be seated. Ms. Rich, is the state prepared for closing arguments?
We are, Your Honor.
And ladies and gentlemen, the state of Indiana has the burden of proof, therefore they go first and last. So you may proceed with your first closing argument.
Thank you. Ladies and gentlemen,
Thank you,
this
Salty.
is domestic violence. It is ugly, and it's sad, and it might not be the exact picture everyone had in their minds when they walked into the courtroom yesterday morning. But this is what it is. We heard testimony that Takesha was just stuck in this circle of abuse and toxicity. And the final straw was this May 30th, 2024 date. Because of this defendant's actions, he is charged with 3 counts: domestic battery, resisting law enforcement, and criminal mischief. I want to break these down a little bit.
Okay, Micro Psycho.
We talked in jury selection that in order for the state to prove domestic battery beyond a reasonable doubt, we need to prove that the defendant knowingly touched a family or household member in a rude, insolent, or angry manner. The state does not need to prove anything beyond those elements. Now, in Indiana law, there are certain ways this gets elevated. Like if the victim is pregnant, that's another check on the checklist. That elevates this. If the victim is under 14, that's another way to get it elevated, and it adds an element to the checklist. But what you all are considering is the most basic version of this statute. You just have to ask yourself, Did he touch her in a rude, insolent, or angry manner? You know, there doesn't even need to be an injury. There is some here, and an injury is always helpful, it's good evidence, but it's not something the state needs to prove beyond a reasonable doubt. So that is the question. Did this defendant?
Sorry, Jim, I wasn't
Keisha
paying
in a rude,
attention.
insolent, or angry manner? And I think the resounding answer is yes, and she gave this particular statement, I'm going to play a small portion of it, to Officer Adams.
Yes.
We've been in situations.
Who's CJ?
He was my boyfriend.
Okay.
We've been in situations, breaking in and stuff like that. We were in here watching the movie. He must have already been drunk before we picked him up. We got to drinking more. He sat in front of my sister, made her feel uncomfortable, trying to flirt with her.
So did you let him in initially?
Yes,
Okay.
yes. So yeah, upstairs now. I let him in initially.
Probably.
So I went off to check it. It was a girl that he had cheated on me with before. We read the messages. I asked him to leave. I went outside. He started acting combative. I asked my sister to lock my door, keep my phone in, my kids, make sure they're good. Went outside. He pulled my hair. His wife's on the ponytail. He threw me on the floor. He threw a glass, which actually cut the bottom of my foot. My wrist is hurt right now because he took it and he swung it. He bust my window to my truck in the front.
Did you see him bust your window?
Yes, I'm so sorry.
That's a stupid question.
I ended up walking out the other way. And then when I came back this way, I didn't see him. So I thought he was gone.
And that's just a small portion, but first of all, you can see there is dirt on her stomach area, particularly right here, and it's a little hard to tell, but there might be some here as well. But you also see that this is a woman, she is shaken. You can hear in her voice that she is trying to be strong, that she is trying to keep it together, but she's talking really fast in a very staccato way. And you can hear her voice breaking more and more into her interaction with police. This is what someone looks like who has just been through something. And she continues to become more and more upset when Officer Orville comes in to take pictures just a few
You
minutes.
injured there?
He cut my foot.
Oh, you cut your foot?
He threw a glass. If you guys don't see it, it's right
Right,
outside
okay,
on the stairs.
on the
So
stairs.
it went into my crock and it cut my foot.
Okay. You want to take a seat so you don't have to worry about falling. I'll take it. Did he damage your vehicle?
Yeah,
Yeah.
my windshield. And he swung my wrist so
Okay.
right now. And he pulled my ponytail. I was in.
I'm gonna take a couple.
My wrist is so sore. Yeah. Because it just popped. And then I just walked. And I grabbed on. It's just my wrist. So you
Is
just,
Okay, I'll take a photo of it, just in case if a couple days have bruises or whatever.
it was
Let-
swollen up.
and we'll come back. We'll take some more photos. Okay. Did anything happen inside?
No,
damage
we went
inside?
outside
Outside,
because
okay.
we realized he had already been drinking too much. So we went outside. And I asked him about some stuff in his phone and he just went crazy. So I asked my sister to lock my door because my kids are upstairs. And that's when he attacked me and bust my window.
He said he pulled your hair.
Yeah, but it just took my ponytail out.
That's okay.
Yeah,
I'm
it
gonna
was-
take a photo of your hair here.
But my windshield is probably the worst.
I know you said your wrist hurts. You got a cut on your foot. Does your head hurt from him pulling your hair at all?
No, because my ponytail was at the bottom.
Okay.
So once he pulled it, I dropped to the floor in the grass.
Okay.
It's just my windshield.
So here, again, you see her walls are coming down more and more. And after just being attacked by someone she loved, having officers in and out of her house, and people taking pictures of her, we see Takesha in a very raw and very vulnerable moment. Now, it's a little bit different than how she testified and her demeanor when she testified yesterday on the stand. You could tell when she was on the stand, she had more than armor up. But we see right after this incident happened, we see a much different, softer, and vulnerable side to Takesha. But despite this, despite the stress she's undergoing, despite having just been in the yard getting her hair pulled around, she is still able to give a narrative. She is able to give a comprehensive version of what happened, what hurts, why it hurts, what's going to be outside. She's still able to talk to the officers and have a back and forth. Which you compare that to the defendant when Officer Byler's talking to him. He's uncooperative. He's clearly drunk, and I think that's pretty evident from the body camera video. And he is not able to think coherently enough to come up with a story that explains away everything. Now, part of that is probably because he is inebriated, his brain is not functioning at full capacity. But the other part of it
Thank
is
you,
he's not
Fozzie.
able to come up with a story because he can't on the fly that explains away every single piece of evidence. Just can't, because there's not an excuse. There's nothing he can come up with that quickly speaking to officers that proves his innocence. Now, ladies and gentlemen, I do want to bring this up briefly. We talked about it in jury selection, but voluntary intoxication is not a defense in the state of Indiana. You don't get to go choose to get drunk and then get a free pass for anything that happens afterwards. So that's not something you can take into consideration when determining these particular crimes. So we have the domestic, and then in the chaos where the defendant is pulling Takesha down by the neck, on top of her, yelling at her, being really derogatory, we also have this criminal mischief. The defendant was out of control. He knowingly damaged the property of Takesha Thomas without her consent. Now, there was certainly some pre-existing damage. Takesha came in and talked about that. The defendant made it.
Fozzie, look what you found. Look what you found. Oh my God. We have a new member called Welsh Lady Reads. Imagine being read bedtime stories with a Welsh accent. Love, I hope you don't mind this, but I mean, I don't think you would mind it because, I mean, that's her. It's awesome. It's so awesome. I can't wait to see her videos. I can't wait to go to bed, guys. I gotta go. I have to listen to this. Okay. Thank you, Fozzie. Thank you, Fozzie. Sue's still waiting. Sue, you have to send us screenshots of your YouTube, of your gifting, so that we can all look at it and see what the problem is.
Worse. There were already cracks, and as Takesha testified, the damage initially was just very surface level. After the defendant threw whatever he threw at this windshield, it made the impact greater, and it created more cracks and damaged previously undamaged parts of that windshield. So it's like if I have my cell phone, and it might have a little crack on the screen already, but if someone comes and grabs it and throws it on the floor, and the spider web grows, they still damaged my phone. That is still criminal mischief, and the defendant is guilty of this count as well. Then we have afterwards, once police arrived because Takesha called for help, he resisted. The state of Indiana needs to prove that the defendant knowingly, forcibly resisted a law enforcement officer while the officer was engaged in the execution of his duties as an officer. When you go back to deliberate, there are a few elements here you do not need to deliberate about. First being that first check, the defendant. This is Sanjay Perry, he's the defendant, everyone identified him. We're all talking about the same person. This is not a whodunit, it's not a question of identity. You can put a check next to that element right off the bat. And then we also have the fact that Officer Byler, he's a law enforcement officer. He was engaged in the execution of his duties as an officer. There's not really any question, he's a sworn law enforcement officer. And arresting someone is certainly within the parameters of his duties as a police officer. So the question is, did the defendant resist this arrest? Did he resist Officer Byler during that process of arrest? I want to play a portion of that clip as well, just so you can see it again.
Oh, put your
Are you
reading
gonna
your
listen
rights.
while I read this to you?
You're not
So
Yes,
I
ma'am.
need to ask you
But
if you
are
can
you
understand-
listening? Because
understand.
I know the law.
Are you listening? I have to read you your rights before I talk
Before
to
you put me in handcuffs,
That's not the
Okay.
case.
Are you gonna listen or no? Otherwise, she's not even gonna talk to you, and you can just go straight to jail.
and then we can take that to court.
That's fine.
That's fine. Okay.
We'll just do that.
But
then.
wait, you can read
Let's
my
walk this way.
rights. Hold on, you can read my rights.
Let's go. Walk this way. Walk
You can read
this
me
way.
my rights.
Walk this way.
I mean, I understand what you're saying, but I know the law. You're supposed to
don't.
read me my rights before you
don't
put
know
me
the
in
law.
handcuffs.
Stay right here against the car.
You're supposed to read my rights.
Stay right here against the
Or drunken Smurf. Or, and hear me out, I can loop this part right here over and over again for you to fall asleep.
Miranda rights, you're supposed to read
Face
me my
the car.
Miranda before you put me in
Stop
handcuffs.
right now.
I'm not fighting you, bro.
Let's stop. Stay
You're
right there.
supposed to read
Spread
me
your
my
legs.
Miranda rights.
Spread your legs for me.
You're supposed to read me my
Spread
Miranda.
your legs for me.
No, you're supposed to read my law. I know the law.
You
You're
don't.
supposed to read. I do. You're supposed to read my
Come up again. You're going to the ground.
I didn't do
You
nothing
understand?
to you are. You
You're not
do.
gonna
If I had a nickel for every time. Never mind.
Yep.
You're supposed to read me my Miranda rights. Okay. I'm not fighting.
You are. You're not listening. So now we're gonna go to the ground.
That's cool.
You know?
Yeah, that's cool. But you're supposed to read my Miranda.
Beside
That's
Chuck.
cool. You little ass motherfucker. You don't know shit. That's cool. You ain't did shit to me. You know, young ass motherfucker. You don't know who I am. That's cool. Oh, read me my Miranda.
Yeah, there were kids in there.
So you see there, in leading up, he's pulling away when the handcuffs are going on. They're trying to walk the defendant to Officer Byler's car. It's being difficult, even just
She called the police. Somebody called the police on him. I think her sister.
walking to the car, kind of, being reluctant. And then we get to the point where the defendant is at the car and he is pushing against the car into Officer Byler. To the point where during this, Officer Byler's body cam is knocked off and onto the ground. And you can hear the officers telling him, stop, you're not gonna push against us, stop. So the defendant can say all he wants, I'm not fighting you, I'm not fighting you. And yeah, he wasn't like brawling with them, but he was certainly resisting. Now, I want to draw your attention to some other cases. So this is case law, meaning that a separate case from this one was looked at by either like the Indiana Supreme Court or Court of Appeals to just clarify some of what forcible resistance means. So in one case, Glenn versus State, the court held that evidence that the defendant on more than one occasion aggressively tried to pull away from an arresting officer was sufficient to establish forcible resistance as required for a conviction for resisting law enforcement. So in this particular case, we have a defendant at least more than once kind of just pulling away as they're trying to arrest him. And that was sufficient for resisting law enforcement. Additionally, we have Johnson versus State, where a police officer twice asked Johnson to move his vehicle because it was blocking traffic. When Johnson refused, the officer elevated his lights, stepped out of his cruiser, and approached Johnson's driver's side door. Johnson again refused to move his vehicle, and the officer placed him under arrest. While being searched following arrest, Johnson turned and pushed away with his shoulders while cursing and yelling. After being searched, Johnson refused to get into the transport vehicle, and he stiffened up, so the officers had to exert physical force to place him inside. We concluded Johnson acted forcibly and affirmed his conviction of resisting law enforcement. So that second case is pretty similar to the one that we
Mommy's closet. I don't know who you are, but you belong in here. We want to hear from you.
have here, where in this case, Mr. Johnson was pushing away with his shoulders and cursing and yelling and refusing to get into the transport vehicle. You can see with these other cases and what courts have found this law to be, there doesn't need to be this huge amount of force. You don't need to, punching the officer in the face or kicking him. That's something different. That's called battering on an officer. Here, there is resistance, forcible resistance to the officer acting according to his duties. And this is all because of the defendant. Takesha Thomas is not the one on trial. The officers are not on trial. Sanjay Perry is on trial and the choices he made. He chose to be violent with someone he supposedly loved. Someone at one point that even wanted to get
Whoa,
married.
everybody stop what you're doing. Hey, Tina, how are ya? Tina, how was your birthday yesterday? Was it nice? What did you do? Was there alcohol involved? Were you arrested? Because that's a good birthday. I hope your birthday was great. There's a lot of happy birthday comments in yesterday's video.
Being hurt by someone you love so much has got to be physical, emotional, and psychological torture. Takesha testified that at one point in their relationship, the defendant was her best friend. And she even said he was all I had. And so she kept going back.
Been
And
there.
it's easy to see why it's hard to fault her for having hope in this relationship where he's all she knows. Her whole world seems to be wrapped up in him. That's why she maybe downplayed some of those past incidents. It's kind of easy to
Yeah, but they're
understand that
orange.
the whole world is wrapped up in someone in some kind of twisted Stockholm syndrome type of situation. But Takesha finally said enough is enough. Ladies and gentlemen, we implore you to hold this man accountable for his actions. We are asking that you find him guilty of domestic battery, criminal mischief, and resisting law enforcement. Thank you.
Thank you, Ms. Rich. Schweinsteiger?
I'd like to thank you all for your attention to the trial. Ladies and gentlemen, please understand that your job as jurors is to focus on the facts of May 30th of this year. Do not let the state of Indiana cloud your judgment, muddy the waters with other incidents, which is what they're trying to do. Other acts, other situations that may have occurred between my client and Ms. Thomas are not what you're here to decide.
I love you, Michael.
That is not the focus. You're here to decide whether or not my client committed the 3 counts that he's alleged to have committed on May 30th. And that's it. Number 1, did he touch her? Is he guilty of domestic battery? I would like to turn your attention to a number of issues. First of all, let's take a look at some of Ms. Thomas's testimony and some of the facts in the case. Remember the video of the technician that took pictures of her? If you recall, she turned around in that video. And you can see the back of her t-shirt. There's no grass stains on the back of that t-shirt. There's no dirt on the back of that t-shirt. All you see is a little spot on the front of her t-shirt, on that white t-shirt. Ms. Thomas testified that when he pushed her down to the ground, they had a struggle. She said that's what happens when you're attacked. And that he was on top of her and they were struggling in the grass. I would question that. If that happened the way she says it happened, there would definitely be evidence of a struggle on her white t-shirt. Absolutely. And the evidence shows from that video, from the tech that took the picture, there was nothing. Recall when you were a child and you're playing out in the grass. If you're playing out in the grass in a white t-shirt, you're going to have some type of evidence on your t-shirt of playing in that grass. The ponytail holder, she did testify, and we just heard it on the video again, that she said that he pulled her ponytail and that it was at the bottom of her hair, that it was low in her hair. That could have come out when she was outside. My client told Officer Feiler that she broke his phone, and he himself testified that his broken phone case and phone screen was found right outside by the front door.
Bonjour. Hey, Charlotte. Guess what? Charlotte. I got something. I got something for you, Charlotte. Are you still here? Oh, there you are. Look, 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 look. That's your birthday card to the judge. Guess what it is? I already sealed it. I didn't think I was going to do this. It's a Beetlejuice card, just like he was wearing the other day. And when you open it, the worm comes out of it. That's what you got him for his birthday. He's gonna love your card. And there's my card. I'm gonna drop it off. I'm taking it outside right now. Stamps are on. Oh, I have to take pictures for us for the. Don't forget, guys, when you send your card to Judge Fleischer for his birthday, make sure that you take a picture so that we know you sent the card, because I'm gonna be hard judging anyone who does not send a card. I put it in Discord in the right channel, or Fozzie will go crazy. You know how he gets.
Remember, when she testified, she told me that she was furious when she came outside because of the phone call that she answered from his phone and the text messages that she read off of his phone. She was furious. She was upset. She was angry and she was mad. She wanted you to believe that she wasn't upset with him flirting with her sister, that she's used to that behavior from him because that's how he is. She wanted you to believe that she wasn't that upset, but then the phone call came, and this was a girl that he had previously cheated on her with, but then she admitted that she was furious.
Yesterday, I got my first timeout. I was timed out by someone yesterday. I'm not going to name any names. There's definitely no yous in this person's name who timed me out for the first time in someone's channel. Yep. Actually, Fozzie yesterday, I I had information I wanted. I didn't know I wanted this information, but Fozzie said, I have some information for you. And I said, yes, I want this information. Give me the information. And he said, no. He said, here's what the information is about. I'm like, no, give me the information. Give it to me. He said, no. So then I cried to everybody. I told him I told everybody he made me cry, and I lost my giggle. So he sent me a tiny little more of the information. he he did this all night at work. I'm like, ah, forgot that person's ranch because I'm looking for my information on the phone. Where's the information? And then the worst part, this is what he did. He typed the information in Discord, but he didn't press send. So it just looked like Fozzie was typing forever. And he sent me a picture of the information that was so far away, I couldn't read it. And that is what Fozzie did to me all night long. So, yeah, JoJo. Sorry, JoJo's here. JoJo. How was your birthday? How was your birthday, JoJo? You and Tina P had a good day yesterday. All right, back to work.
That she came outside, she told her sister to lock the door, but then she told the tech that was taking the pictures that her children were upstairs. And again, it's interesting to note that she told her sister to lock the door, and that her sister stayed inside, but her sister saw nothing. And that this incident outside lasted approximately 5 to 10 minutes. She didn't recall exactly.
Next year, it's her birthday, guys. We got to show her how to do her birthday right. Actually, Tina P, where are you? What state, city, whatever you feel like giving? You can even lie. No one will know. We will rent a block of hotel rooms on a real high floor. Let's go real high. And let's go somewhere with a pool. Oh man, it snowed today, so now I really want to swim. So next year we'll all meet up. Everybody start saving. And we'll all meet up to do Tina's birthday right. And if JoJo comes too, woohoo! Then we'll do double birthdays. Vegas does sound like a good idea, Donald. Hi, Jody. Oh, she's from Maine. She wants to swim now too because it's cold.
She didn't time
It's
it.
not that cold.
It's interesting though that her sister never once looked out the window, looked out the door, that she wasn't a witness to anything that went on. Maybe it's because nothing did go on. And maybe her ponytail came out because she broke his telephone, because she was upset because a woman was calling that she answered the phone.
Who wants to be on the panel? Who's going to be on the panel? Mod panel or member panel or just a panel? We have to do this con right. I have so many merch ideas. So many merch ideas for this panel. We need people to man these booths. Hi, Terry. Terry, we're all going to go to a con, Vibe Con. Yes. Maybe maybe he's asleep. Should I call him? Should I call Fozzie and see if he's awake? Listen, don't get married on your birthday. It takes away from your birthday. Happy anniversary. 25 is a good one. Okay, back to work, guys. Come on.
And didn't like what she heard. The glass that's on the walkway by the stairs leading up to the house. Officer Weiler testified today that he saw no blood. Takesha testified that there were big pieces of glass. You saw the photograph that the tech took. Those weren't big pieces of glass. Those were small pieces of glass. She also testified, we saw that video again today, of her timeline of when things happened. She said that she was thrown into the grass and then he broke the bottle. There was no blood by the glass. She wants you to believe that this glass was thrown at her and that it fell into her crop. Not that she stepped on glass that was previously broken. She also wants to complain, state that her wrist was turned. There's no marks on her wrist. There's no redness to her wrist. Ladies and gentlemen, my client, while he was never afforded, and it's the police officer's job, as Officer Weiler admitted today, it's always important to get both sides of the story. My client has no duty to testify.
She was wearing Crocs. She was wearing Crocs, and the glass went up through the Croc and into her foot.
Corporal Adams did not get my client's side of the story. Yes, there may have been some arguments about Miranda rights. But Officer Weiler was outside, and my client told Officer Weiler that he did nothing, that he didn't do anything. He didn't put his hands
You're
on
not
his
wrong.
phone.
You're not wrong.
He didn't touch her. He not only did say that to Officer Byler, but to Corporal Adams when he asked what he was being arrested for. And he said that she lies.
Security will probably be in
Corporal
here
Adams
in her
never took
good
the
time.
time to pull Officer Byler aside to find out, well, what did Mr. Perry tell you? What did Mr. Perry tell you now? Instead, after 3 minutes and 40 seconds of talking to Miss Perry inside, she walks out the door and says, "Papa, that's not fair to Mr. Perry.
I didn't see anything
Would you want
blocked.
that to happen to you in that situation? Would you want that to be you? Not having afforded the right to have the officer talk to the other officer to at least know, well, what did he tell you? What did he say happened? No, you're just gonna go to jail. Doesn't matter what this woman inside said. Doesn't matter that she's upset, she's a sworn woman, she's upset that she's pissed off because of voicemails and text messages that she's heard. And now she wants her revenge. Let's talk about the criminal mischief charge. You've seen the state's picture, which is probably the best picture of the damage to her vehicle. The picture that was taken.
Peg Leg, you've seen enough. I asked everybody else, but nobody really gave me a solid answer. Criminal mischief is one of the charges. Resisting arrest is the second charge. Domestic violence is the third charge. Is he guilty or innocent on any of those charges? What happens in, what time is it? What happens in 15 more minutes? What do we think, guys? What happens to this poor kid who is a victim of a woman who's doing this for revenge? 3. So one of them he doesn't get charged on, June. Okay. No evidence of domestic violence so far. Okay. Not guilty. Of all 3? It's just not guilty. All right, here we go. Let's get moving.
And on May 30th. I also showed you defense exhibits A, B, and C that showed previous damage to her vehicle.
Nobody's paying attention.
It is
fine.
clear that on May 6th and on May 22nd, she already had damage to her vehicle. Whether or not my client did that damage is not the issue.
Sir, you never wait until you see the whole thing before you start judging someone. Don't even start. Don't start today.
That is not what we're talking about today. That's not what you are to consider. But what you are to consider is that there was damage to her vehicle already. And when you look at the state's picture, which is the best picture, you really have to look at the point of impact. She wants you to believe, and she even testified when I said, so you're telling me that whether he hit the vehicle with a bottle or a cell phone, that he hit it in the exact same spot? She said, yes. Because when you look at that picture, there's only one impact spot. There's not 2 different cracks. There's only one impact spot. And either he's got really, really good aim in his alleged drunken state, or he did not damage her vehicle on May 30th. She just wants you to believe that, to add to her story. Ladies and gentlemen, her vehicle was already damaged. However, it was damaged previously. It was not reported. This was her opportunity to place blame for damage to her vehicle. And she was using this incident on May 30th to blame my client for that damage. This was not damage that he caused on May 30th, and he's not guilty of damaging the vehicle on May 30th. There was also no pictures taken of any glass, any phone screen fragments found on the vehicle, in the, around the vehicle, on the streets. Phototech didn't have any photographs of anything from the damage to the vehicle on May 30th, which is more evidence that there was not damage from May 30th to the vehicle. Also, when my client was searched, he was only found with a wallet on him, no cell phone. To this date, this cell phone has never been found. Lastly, on the resisting charge, my client tells the officer, "I'm not trying to fight you, bro." That is in Corporal Adams' video. He says, "I'm not trying to fight you, bro. I'm not trying to fight you, bro." Officer Byler testifies today that he was not actually trying to fight. My client states, "I'm going to move how you want me to move. I'm going to move how you want me to move." He repeatedly says, "I'm trying to help you. I'm trying to help you." Those are his words. And in his mind, he was not resisting law enforcement. And the officer that he's alleged to have resisted law enforcement stated again today in his own testimony that he was not actually trying to fight. Again, ladies and gentlemen, use your common sense. Keep an open mind. Remember who the upset person was here, who the angry person was here, who the person was that wanted revenge. And please do not, again, do not allow the state to muddy the waters with prior situations that are not relevant to May 30th. You're here to judge the facts and the situation that allegedly occurred on May 30th. Again, instruction number 6 that was read in the beginning is very important. If you have evidence in front of you that lends itself to 2 reasonable interpretations, you have to choose the interpretation consistent with the defendant's innocence. The burden is on the state, and it's a very high burden. And in this particular case, the police did not do justice for my client. It was not justice for them to immediately just listen to what Ms. Thomas had to say, not take into any consideration my client's version of the truth, or to give him any justice in this situation. And I ask that you give him that justice today and find him not guilty. Thank you.
Thank you, Ms. Swinsker. Ms. Rich?
So Takesha is not a woman scorned, she is a woman abused. The defense here is trying to make you think that she's crazy, that she's this crazy liar. So don't listen to the state, don't believe Takesha, don't believe the officers, don't believe the evidence. Which is exactly what the defendant was trying to do when the police got there. So the state, we're not clouding judgments, we're not muddying waters, the state presented evidence. And we did present evidence that there was hostility in this relationship. And it culminated on May 30th, 2024. Now, quick aside note on the resisting law enforcement charge. I hit this in my first closing, but just to be really clear, there is a big difference between active fighting, blows, punching, and resisting. What we're talking about for this case is that forcible resistance, kind of like what I described earlier. But then we also have the criminal mischief. Takesha noted several times the difference in the pre-existing damage and the damage here in this exhibit. Takesha came in, she talked about it, she wasn't hiding it or anything. And we have State's Exhibit 10, and it's really hard to see, but Officer Gorbel touched on it, that there is some debris on top of the hood. And if you look really closely, there is something sticking out of that windshield. So if something is on top of that hood, right directly from the damage, and there even appears to be something closer to the shards, this looks like fresh damage. That something has recently happened to this car, which supports Takesha's narrative. It supports how she testified. I think juries, especially in these cases, sometimes get the temptation to silo evidence. And what I mean by that is sometimes juries will think of a piece of evidence, put it in a vacuum all by itself, try to find a way to explain it away, and then move on to the next piece. And just look at it by itself in isolation, and then try to find a way to explain it, and then move on to the next piece of evidence. Which is also ultimately what the defense was asking you to do. But it doesn't work like that. All of the evidence, all of the testimony weaves together. So it's kind of like music. You have one music note, doesn't really mean a whole lot. But when you add more and harmony, percussion, and instrumentation, and put it all together, it works together to create music. And that is what we have here. So the defense is that Takesha is a liar. She is apparently trying to go through all of this fuss because she was mad about what she saw on the phone. And that's really what he has to go with, because there is no other good defense. There is nothing else that even comes close to explaining away the evidence in this case. So we hear there's no grass stains, that there's no way a struggle happens because there's no grass stains on her shirt. But she does have dirt on her shirt. We saw that in Adam's video. So how else did the dirt get on her shirt if there wasn't a struggle? There's a hair tie in the yard. How did that hair tie get in the grass? If Takesha's this big liar that just wants to get him in trouble. She even said to Officer Adams, I don't want him to go to jail or nothing. She wasn't trying to ruin his life. She was just trying to get some help from the police. I encourage you to look at all of the corroboration in this case. So Takesha gave her statement, and there is a lot of corroboration. Because crimes like these, domestic violence, these are not committed in front of an audience. It's not like there was surveillance video. It's not like Takesha is wearing a body cam like the officers. So we look to other points of evidence. For example, Takesha said her hair was in a ponytail and the ponytail got pulled out. When officers are there, her hair is down. Then they find a ponytail in the grass. She says he threw a beer bottle. There's a broken beer bottle on the sidewalk. She says glass went into my crock and cut my toe. And she has a cut on her toe. You see her demeanor. She is upset. She's clearly been through something, and the police got there fast. And just ask yourself, what makes sense? Did she, in a matter of minutes, put together this elaborate ruse that explains away trace evidence that officers are barely finding in the grass? Look at her. She's upset. She's clearly been through something. And I think it might be a little challenging for some people, especially when Keisha was on the stand. She wasn't necessarily crying like she was crying in the video, but she just has to be credible. She doesn't need to be huggable. She just needs to be believable. And I think she is. We compare this to the defendant's demeanor at the scene. Clearly trying to take control from the get-go. He first off tries to be real smooth with the police and walk down and try to be real casual. And while he is in that state, trying to win them over, he starts throwing her under the bus immediately. She's in her feelings. She's bipolar. My cousin is the mayor. And when that doesn't work, when he's not able to control and manipulate the police like he's been able to do to Keisha for 7 years, he gets belligerent. You saw how the defendant acted if he doesn't get his way, and that was towards police officers. Just think about how he acts with his girlfriend when she doesn't get his way, or when they disagree. As we saw in the video with law enforcement, he was quick to get aggressive. He says, "You don't know who I am," and his tactic is to put the police on the defense, and so he can maintain that psychological leverage at the scene. So he can
left
be
us.
in control.
He left us all alone. Who's in
The
charge
defendant
now?
says, read her statement, she lied. Keisha talked about that, and he's trying to use that as some kind of leverage to, again, try to manipulate and control, because he was able to successfully do so in the past. Keisha was stuck in that cycle of violence and trying to protect her abuser when she backtracked her initial allegations.
Good idea,
It
Nan.
was sad, but certainly not uncommon. You heard Officer Adams testify that she goes to these calls pretty regularly, and she often sees victims get back together with their abusers, and she went through all of the reasons why, and I'm not going to hash that out. I think you all picked up on that. Because people like Sergeant Perry, they have to be in control, because that's what domestic violence is. It's domination, manipulation, and control. You can see how Keisha got sucked in.
There was information
And
I
there were
needed.
7
I needed.
years of this. After 7 years of this, she was stuck. She probably didn't know any other way. It was her normal. But she finally stood up to her abuser, and she stopped letting him control and manipulate. Police were not going to fall for his manipulation. Don't let him manipulate you. For this other reasonable side to be present, it needs to be reasonable. It needs to be reasonable that the defendant didn't touch Keisha. And that is clearly not the case. You are the jury. You decide what happened here. You believe to Keisha that this happened, that there was a rude, insolent, or angry touching. That's the conviction. Ladies and gentlemen, when you come back finding the defendant guilty, you are not going to be telling him anything he doesn't already know. Thank you.
Thank you, Ms. Rich. Please.
Fletcher, what's that song? You've never even called me. Never even called me by my name. Okay, Fletcher. It is what? Friday night. It's Friday night, which is, I'm still in Friday night, by the way. It's Friday night. Everybody's just listening to this. we have this country band tonight. It's the very end of the night, right? Fletcher, I'm talking to Fletcher. And so, people were fine. People were fine all night long. They were just sitting, they were eating, they were drinking. A little bit of singing with the band, not too much. It was just a chill night at the bar. Okay. And then they played that song. Then they were like, okay, guys, one last song and we're out of here. And they started playing that song. You never even called me by my name. Wow. Fletcher, you need to put that on your playlist. Even if you don't like country, I'm telling you, every single person was standing up and singing and clapping, and they had their phones out. They were recording. And I'm just standing there like all these great songs they played all night long, and nobody blinked. And then they played this song, and everybody just went crazy for some reason. Yep. I don't know why, but you should put it on your playlist, because when they hit that last verse, when they hit that amazing last verse to make it the perfect country song, everybody was they were just and they weren't drunk. It was just awesome. It was amazing. Put it on your playlist.
Gentlemen, at this time, the court will distribute to you the final instructions. It appears that everybody has a copy. Again, I will start on page 2, where it reads at the top of the page, instruction number 1. You are to consider all the instructions together. Do not single out any certain sentence or any individual point or instruction and ignore the others. Under the Constitution of Indiana, you have the right to determine both the law and the facts. The court's instructions are your best source in determining the law. These instructions do not contain any information concerning a possible sentence. The court alone is responsible for sentencing if there is a conviction. In this case, the state of Indiana has charged the defendant, Sanjan R. Perry Jr., with count 1, domestic battery, a Class A misdemeanor, count 2, resisting law enforcement, a Class A misdemeanor, count 3, criminal mischief, a Class B misdemeanor. The charges read as follows. Count 1, on or about May 30, 2024, at the County of Elkhart, state of Indiana, one Sanjan R. Perry Jr. did knowingly touch another person, to wit, one Takesha Thomas, a person who is a family or household member of the said Sanjan R. Perry Jr., in a rude, insolent, or angry manner, all of which is contrary to the form of Indiana Code 3542-1.3, subsections A1, contrary to the form of the statute in such cases made and provided, and against the peace and dignity of the state of Indiana. Count 2, on or about May 30, 2024, at the County of Elkhart, state of Indiana, one Sanjan R. Perry Jr. did knowingly forcibly resist, obstruct, or interfere with a law enforcement officer or a person assisting the officer, to wit, Officer Bryant Filer of the Elkhart Police Department, while the officer was lawfully engaged in the execution of the officer's duties, all of which is contrary to the form of Indiana Code 3544.131, subsections A1, contrary to the form of the statute in such.
Blah, 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 blah. Donald, that's fair, because you're an actor and you read the script. And I heard, unless you are a very, very, very important person, if you go off script, it's a bad thing. No improv.
Cases made and provided, and against the peace and dignity of the state of Indiana. Count 3, on or about May 30, 2024, at the County of Elkhart, state of Indiana, one Sanjan R. Perry Jr. did knowingly or recklessly damage or deface the property of another person, to wit, property of Takesha Thomas, without the consent of Takesha Thomas, all of which is contrary to the form of Indiana Code 3543.1.2, subsection A, contrary to the form of the statute in such cases made and provided, and against the peace and dignity of the state of Indiana. The charges which have been filed are the formal method of bringing the defendant to trial. The filing of a charge or the defendant's arrest is not to be considered by you as any evidence of guilt. A plea of not guilty has been entered on behalf of the defendant. Under the law of this state, a person charged with a crime is presumed to be innocent. This presumption of innocence continues in favor of the defendant throughout each stage of the trial. You should fit the evidence presented to the presumption that the defendant is innocent if you can reasonably do so. If the evidence lends itself to two reasonable interpretations, you must choose the interpretation consistent with the defendant's innocence.
I don't know. I'm not old.
If there is only one reasonable interpretation, you must accept that interpretation and consider the evidence with all the other evidence in the case in making your decision. To overcome the presumption of innocence, the state must prove the defendant guilty of each element of the crime charged beyond a reasonable doubt. The defendant is not required to present any evidence to prove his innocence or to prove or explain anything. The burden is upon the state to prove beyond a reasonable doubt that the defendant is guilty of the crimes charged. It is a strict and heavy burden. The evidence must overcome any reasonable doubt concerning the defendant's guilt, but it does not mean that a defendant's guilt must be proved beyond all possible doubt. A reasonable doubt is a fair, actual, and logical doubt based upon reason and common sense. A reasonable doubt may arise either from the evidence or from a lack of evidence. Reasonable doubt exists when you are not firmly convinced of the defendant's guilt after you have weighed and considered all the evidence. A defendant must not be convicted on suspicion or speculation. It is not enough for the state to show that the defendant is probably guilty. On the other hand, there are very few things in this world that we know with absolute certainty. The state does not have to overcome every possible doubt. The state must prove each element of the crimes by evidence that firmly convinces each of you and leaves no reasonable doubt. The proof must be so convincing that you can rely and act upon it in this matter of the highest importance. If you find there is a reasonable doubt that the defendant is guilty of the crimes, you must give the defendant the benefit of that doubt and find the defendant not guilty of the crimes under consideration. In this case, the defendant is charged with multiple counts of criminal offenses. Although all of the counts are contained within one charging
I
document,
bought it
you
myself.
are to consider the law and the evidence as it may.
I haven't bought a new shirt for myself in, I don't know, how old's my oldest? 24? I don't know. It was great.
Apply to each count individually and separately from the other counts. The crime of domestic battery is defined by law as follows. A person who knowingly or intentionally touches a family or household member in a rude, insolent, or angry manner commits domestic battery, a Class A misdemeanor. Before you may convict the defendant of domestic battery, the state must have proved each of the following elements beyond a reasonable doubt. 1, the defendant. 2, knowingly. 3, in a rude, insolent, or angry manner. 4, touched Takesha Thomas, who is a family or household member of defendant. If the state failed to prove each of these elements beyond a reasonable doubt, you must find the defendant not guilty of the crime of domestic battery, a Class A misdemeanor charged in count 1. The crime of resisting law enforcement is defined by law as follows. A person who knowingly forcibly resists, obstructs, or interferes with a law enforcement officer or a person assisting the officer while the officer is lawfully engaged in the execution of his duties as an officer commits resisting law enforcement, a Class A misdemeanor. Before you may convict the defendant of resisting law enforcement, the state must have proved each of the following elements beyond a reasonable doubt. 1, the defendant. 2, knowingly. 3, forcibly. 4, resisted, obstructed, or interfered with Officer Bryant Feiler, a law enforcement officer, while the officer was lawfully engaged in the execution of his duties as an officer. If the state failed to prove each of these elements beyond a reasonable doubt, you must find the defendant not guilty of the crime of resisting law enforcement, a Class A misdemeanor charged in count 2. The crime of criminal mischief, a Class B misdemeanor, is defined by law as follows. A person who recklessly or knowingly damages or defaces property of another person without the other person's consent commits criminal mischief, a Class B misdemeanor. Before you may convict the defendant, the state must have proved each of the following beyond a reasonable doubt. 1, the defendant. 2, recklessly, 3, damaged or defaced the property of Takesha Thomas. 4, without the consent of Takesha Thomas. If the state failed to prove each of these elements beyond a reasonable doubt, you must find the
Do you want me to fast forward through the jury instructions?
defendant not guilty of criminal mischief, a Class B misdemeanor, is charged in count 3.
Yeah, I take that as a yes. Okay. All right.
the jury unless I direct you to do so. The foreperson shall prevent the alternate juror from deliberating or voting with the jury. The foreperson shall promptly report any violations of this instruction to me. And folks, you can set those instructions aside and you'll be able to take those back with you to the jury room.
And at
This
every
time, Mr.
break.
Warren, I will have you come forward so that I can administer the oath of the bailiff. Do you solemnly swear to keep the jury together in the jury room in this courthouse, to permit no person to speak or communicate with them, to speak or communicate with them yourself
I
only by
remember
order of the court, and
too.
to
It was
ask them whether they
awesome.
have agreed upon a verdict, and to return them into court when ordered by the court? And do you further solemnly swear that you will not communicate to any person the state of the deliberations of the jury, so help you God? Thank you. So folks, we are going to send you back to the jury room at this time. We will collect the exhibits and send back those that we are allowed to send back to you. We will also clear the courtroom. I know that there are only 7 of you. Sometimes we have 14 people that we stuff into that tiny little room. But I can assure you, even though there's 7 of you, it may get hot at some point in time. So we are going to clear the courtroom and you are welcome to spread out. Sometimes the jurors will take tables and put it together as a conference table. Do whatever you need to do to make yourselves comfortable.
I thought that was
But we
cool.
will do that and that will take us a few moments. So we're going to send you back to the jury room right now. Please rise to the jury. If there is a finding of guilt on count 1 domestic battery, the court will then advise the jury that there is a second phase to the trial. I will send them back to the jury room and then we'll have a further discussion about whether or not the
Yo,
defendant
thank
wishes
you,
to
Adam.
admit to that second phase. And I will ask the requisite questions. Other than those matters, is there anything else from the state's perspective that you wish to address before we bring the jury back in?
No, Your Honor.
This is the only picture we see for the rest. That's it. We just get to hear. She didn't turn her cameras on.
Ms. Schweinsker.
Wench.
Okay, let's go ahead and bring the jury back in.
I
Please rise to
resemble
the
that
jury.
remark. I hate jury selection. I hate it. I would rather clean. I would rather jog.
Thank you. Please be seated. Ladies and gentlemen, the court has been advised that the jury has reached a verdict. This time I will direct that the bailiff collect the verdict forms from the
I am your wench. Just putting that out there.
foreperson.
I'll grab the other 3.
All right, very well. So we will need to have the other forms to complete this. All right, with respect to count 1, we, the jury, find the defendant not guilty of domestic battery, a Class A misdemeanor. With respect to count 2, we, the jury, find the defendant guilty of resisting law enforcement, a Class A misdemeanor. Count 3, we, the jury, find the defendant not guilty of criminal mischief, a Class B misdemeanor. Ladies and gentlemen, at this time, this concludes your service as a juror. We will send you back to the jury room. We do have just some final matters that we need to address outside of your presence. It won't take us very
Out.
long. And we will
Young.
let you know when you are free to leave.
So not guilty. Terry. The other Terry. The Terry with an I. Terry called it. Resisting arrest. That's it. That's all, that's all he got. He didn't get anything else. So that guy is going to jail now. He's going to jail. Like he's been taken into custody. He had some priors, obviously. He said that at the beginning. So if he would have just cooperated when the police came to the house, he would be free right now. He would not have been found guilty of any charges. But because he did not cooperate to the police and he kept arguing with the police when he was clearly wrong. You have to read me my Miranda rights before you put handcuffs on me. No, they don't. No, they don't. It's for everybody's safety that they cuff people right away. They don't have to do anything before they cuff you. So, I mean, I thought there was enough for domestic violence. I thought I thought there was, but not the cut foot because he didn't cut her foot. She stepped on broken glass, but he did pull her hair and they saw the dirt on her shirt. So they knew she was on the ground. That was enough. Um, but yeah, if they don't, it was that ponytail. That ponytail did a lot of damage. So the one female officer was on stand and they're like, "Are you, your body camera doesn't show you seeing that ponytail. You said you saw that ponytail. The body cam doesn't show it." And the officer's like, "Well, the body cam doesn't show everything I see." Well, what if I told you that it didn't show you ever finding a ponytail and showed you searching for one. But she saw it. She just didn't pick it up when she saw it. And that lawyer was hard on that ponytail holder, and that might have been it right there. So yeah, that was pretty, 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 pretty bad. Caddy, that's a comment about court. I didn't know you had it in ya. Nice. Good job. I don't know. I think yeah, they called it a ponytail. But yeah, the picture of her crying and the picture of her foot because she stepped on glass. I mean, that's not evidence of domestic violence. Yeah, he probably threw the beer bottle. It didn't get broken by accident, and then she probably stepped on it, but that's not domestic violence. Is it though that she stepped on glass? That's domestic violence? Because if so, my ex-husband, he's going to jail today. I stepped on so many broken dishes because he wouldn't clean them up. Oh, I lose every hair tie except for the last one of the pack. That one I hold on for dear life for 3, 4 years. It was. It did look. That was all braids. That was all braids. Hi, Hedwig. I'm gonna sue his ass. Nah, he's broke. He ain't got no money. Do you want to know? Do you want to know how I know my ex-husband doesn't have no money? Because there's this nifty little app called PA Dockets that we have in Pennsylvania that you can you just look up people's criminal records. It's public. And that man, I looked. I looked about 4 months ago, and that man, every like 3 months, is back in court for eviction. But he doesn't ever get evicted. He just keeps going to court for eviction, paying the bill. Then 3 months later, in court for eviction, paying the bill. He ain't got no money. He's got like 118 kids, man. Well, I guess that he doesn't support them. Never mind. That's not why he's broke. What is two? Two, two, two. What did I miss? I missed something. Oh, no, I don't know. One? I'm a one. I mean, I know what tumbleweed is. Who is this fancy judge? Listen, his suit is orange. We're going to stick with that so we don't fight. We're going to live in a lie so that we don't fight about the truth. Delusions. Yeah. All right. Now I have to look it up because everybody else knows what a tumbleweave is. Don't worry. We're all going to learn together. Nobody knew before this. I am not. Nope. Not showing any of that. I am not showing what a tumbleweave is. Go look for yourself, guys. All right, it's Friday in Judge Fleischer's courtroom. It was a pretty chaotic day for us.
And then the co-defendant is on page 15. Ochoa Gonzalez.
Victor, are you on both cases?
Good morning, Judge. Yes, I am.
Oh, thanks, Steve.
Try it again.
Good morning,
Victor.
Judge. Yes, I am.
All right, let's roll, nerds.
Tumbleweave, like Victoria.
And just so the court's aware, Judge, there is a typo on the first name for Henley's. They've got it as Genyls. It should be Genlys.
With a D like David?
No, the Y and the L need to be flipped, Judge.
V, like Victoria.
Okay. All right. Good morning. I want to let you both know that if you look on the TV, your lawyer is on the TV with you now, so that you're not alone. Both of you are charged with theft. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On November 15th, 2024, officers were dispatched to Walmart in regard to a theft. Upon arrival, officers made contact with the complainant, the asset protection officer, who stated he saw the defendant and co-defendant conceal items in the defendant's purse. The complainant advised that as the defendant was concealing items, co-defendant was staying very close to shield her from others in order to prevent them from being seen and from others seeing what she was doing. Both then exited the store, passing all points of sale with items still in the defendant's purse. The complainant detained the two and recovered the stolen items. Total $112.31.
Okay. All right. Mr. Ochoa Gonzalez
Monica.
and Ms. Fresneda, I am finding that there's probable cause to go forward on both of your cases. Tell me, what is your immigration status? Are you in this country with or without permission? Ma'am?
With permission.
What is your immigration status? Are you a citizen of the United States, sir? I don't know if you do or
It's got
if you
another
don't,
wench.
and quite frankly, it doesn't matter to me. The only thing I'm going to advise you now is that if you have any problems with your immigration paperwork and you go to jail, immigration will put a detainer on you and you will sit in custody first until this case is over with, and then you will be shipped off to immigration and you will sit there for another 6 to 9 months waiting for immigration to do whatever they're going to do. If you do not want that to happen, do not violate these conditions. Do not pick up any more criminal cases. This is the only warning that you will get from me.
I told you security would be in soon. Hi, security.
I'm now ordering you as a condition of your bond not to go to any Walmart for any reason whatsoever. Do you understand?
Okay.
If I find that you go to Walmart and I don't care what your reason is, I will issue a warrant for your arrest and I'm going to put you in jail. You will not get any more PR bonds. Likewise, you pick up another criminal case, you will go to jail. Both of you have a lawyer. It is your responsibility to stay in touch with Mr. Porras, and he will tell you if and when you have to come back to court. If he comes back to me and tells me he cannot get a hold of you because you guys are playing games, you're not responding to phone calls, text messages, likewise, I will issue a warrant for your arrest. For now, I will have you go to Victoria. We will have you sign a reset. After that, I'm going to have you both take a seat in the jury box while we get your bond conditions. Heed this warning. You will not get another one. Okay. Victor.
Yes, sir.
Did you get a date already?
Not yet, Judge.
January 28th through the 30th.
What
We can do the
date?
28th.
Okay. Right, Judge, and then Marcos is approaching on page 2. Alonso Herrera.
Can you file those conditions, please, on both of those? Will you
May I
find
be excused, Your Honor?
Otherwise, should be here. And Jenny's helping out with it.
Say it
Maybe
again?
excuse, Your Honor.
Oh, yeah, you got it. Have a
No,
great weekend, bud.
he
Appreciate you.
doesn't have to, but he has to, because if they go to jail, then they risk a lot of things. A lot of judges, even in Ohio and in Michigan, will say if you are not a citizen, then going to jail will be bad for your immigration status.
You too, Judge.
Sure.
Alonso, A-L-O-N-S-O.
Alonso Herrera.
Thank you.
You, Ruben Alejandro Alonso Herrera.
Yes, Judge.
Sir, you're charged with failure to comply with duty, striking an unattended vehicle. You're facing up to 6 months in jail and/or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge.
Okay.
The officer was dispatched to a residence in Harris County, Texas, in response to a failure to stop and give information. The complainant reported that his brother was standing outside when he heard a loud bang and saw a silver car striking the complainant's car, which had been parked in the street. The complainant and his brother immediately began pursuing the vehicle and observed it parked in front of a residence down the street. The complainant took photos of the defendant exiting the vehicle and going into the residence. When officers asked whether the defendant remembered striking the complainant's vehicle, the defendant stated, "I probably scraped by it, but nothing at all. It was dark out."
What's the value?
Let's see, Your Honor. Approximately $1,500.
Judge, I don't think a rip has been done, so there's no estimate. We don't know who.
Yeah, I get it, but at least it needs to be over $200. That's why. Sir Alonso Herrera, I'm going to find that there's probable cause.
I texted Nan when I was not feeling good, and she gave me some advice. I ran to CVS, got the things for my ankles, and I had a great shift tonight. It wasn't pain-free, but it was less pain.
To go forward with your
Thank you,
case.
Nan.
Do you have a valid Texas driver license, sir?
Yes, sir.
You have valid liability insurance in your name.
No, Judge.
Then you're not allowed to drive. And I'm making that a condition of your bond until you have liability insurance and show us that you have liability insurance. I'm making it a condition of your bond that you're not to drive. I don't care where you're going. I don't care what you're doing. Do you understand?
Yes, Judge.
You will be signing an affidavit with me today promising me that you're not going to drive. If I find that you do, it's possible that I have a contempt
App
hearing.
just spins.
And every time they prove to me that you're driving a vehicle, you can be facing up to 6 months in jail and/or a $500 fine. Do you understand?
Yes, Judge.
Now you have a lawyer. Good job on having a lawyer. Because you have one, I will waive your appearance, but it's your responsibility to stay in touch with Mr. Adroga, and he will tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest.
Yes,
Pick up a new case, violate any conditions. Likewise, you will go to jail. You will not get any more PR bonds, sir. All right, I will have you come up here, swear to us that you're not gonna drive. I'll get you the Victoria sign and reset, and then you guys are good to go.
Hey, Judge, may I be excused?
Yes, sir. Thank you.
All right, Judge, page 1. Adam, come on up. Page 1, Adam.
How many bonds have we given or reinstated for Mr. Adams here?
So 3 in total, 1 GOP, 1 reinstatement.
And
I think I put the WhatsApp mine in mod chat. I think. I don't know.
now he gets another PR bond?
This one was issued with this last one.
Do you have a lawyer today, Mr. Adams?
No, sir.
Your case is 1,258 days old. It is time to put this baby to bed. Take a seat for me. Vic, do you mind appointing him a lawyer, please?
Okay,
Do something today.
next up is page 2. Arvalo. Maryland.
Ms. Aravalo, you were charged, how old are you, ma'am?
20.
Ma'am, you're charged with prostitution. You're facing up to 6 months in jail and or a $2,000 fine. You have already taken off on us 2 times. If it happens a 3rd time, you will stay with me. We'll not get any more PR bonds. Do you understand, ma'am?
Yes, sir.
Do you have a lawyer?
No, sir.
I'm gonna appoint you one today and we will figure out where we go. Take a seat for me in the jury box, ma'am.
Mine,
Next up is page 3.
yeah, nothing's working today because I got a new green screen and the light, it doesn't reach it. So every time if I move over too far or whatever, okay, now it's not going to do it. Everything turns black. Of course, it's not going to do it right now.
Arispe? You speak English, sir?
Back flip or front flip? Do back flip. Do back flip.
You are Tomas Arispe?
Oh,
Yes or no?
what was good?
Are you Thomas Arispe?
Yes, sir.
Okay, sir,
The old green screen was so tiny that it stopped like right here. So my camera always had to be like real high, and the cats really did not like it.
you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes. The officer initiated a traffic stop after observing the defendant make an improper wide right turn at an intersection with traffic lights in violation of Transportation Code 545.101. Upon contact.
Do you ever see those videos where men try to do Simone Biles stuff, balance beam, floor routine? They're freaking hilarious. They get injured. They absolutely get injured, but they signed up for it.
The officer observed a strong odor of marijuana. The officer observed a glass pipe and lighter in the cup holder in plain view. During a PC search, the officer found an unholstered gun below the driver's seat. In the center console, the officer located a clear plastic bag containing marijuana and another plastic bag containing square tablets believed to be LSD.
How old are you, Mr. Arispe?
17.
I'm sending you now for a drug test. I want to know what, if anything, is in your system. You are to take the drug test and you're to come right back. If you fail to take the test, if you fail to come back, I will issue a warrant for your arrest. You will not get any more PR bonds. Do you understand? Okay, take your seat for me.
All right, Judge, next is page 4. Caldwell, come on up.
Oh, you could. You just need a little more ice on the ground.
Oh, and I'm fine, probably.
When you're walking down the steps outside and your one foot hits the ice, but your other foot is still walking down the steps, whoo, you do splits all the time in January, February. As long as you don't spill your coffee or drop your phone on the way down, you're fine.
Jordan Caldwell? Ms. Caldwell, you were charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The officer is dispatched to a residence in Harris County, Texas, in response to a family disturbance. The complainant stated that she got into a verbal argument with the defendant, her daughter, because the complainant believed the defendant was not taking care of her children. At that point, the defendant picked up a baby bottle and threw it at the complainant, hitting her in the cheek, causing pain. The defendant admitted to having thrown the baby bottle.
And I'm going to find that there's probable cause to go forward with your case. I don't show a protective order as an issue. Do you show one? No? Okay. Ms. Caldwell, I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Candy Lachey as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? It's not an answer, ma'am.
Yes.
How old are you, ma'am? Are you here with anyone today? Who are you here with today? I'm sending you now for a drug test. I want to know what, if anything, is in your system, ma'am. You're to come right back. If you fail to take the test, if you fail to come back, I will issue a warrant for your arrest. You will not get any more PR bonds. Do you understand? Okay, can you have her sign the note before she leaves, and then we'll send her for a test, please?
You're done with it, Your Honor?
For now.
All right, Judge, next is page 5, Durden, Aaron?
Yes.
You were Aaron Durden?
Yes, sir.
Mr. Durden, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, yes. Okay. On November 14th, 2024, the officer was on a traffic stop.
Thank you so much. Snoopy, hi. Let's see who we got here. Let's see. A beautiful mess. Yay, Amy in Pennsylvania. Pennsylvania sounds like a really, really nice place to be. Thank you so much. Thank you, thank you, thank you.
In Harris County, Texas, with emergency lights activated when he heard an engine roaring of a performance motor vehicle and observed the defendant's Lamborghini on the feeder road traveling at least double the speed of moving traffic with a posted speed limit of 45 miles per hour. The officer observed the defendant's motor vehicle swerve in the feeder lanes and enter South Highway at a very high rate of speed without signaling a lane change. The officer terminated his traffic stop and attempted to catch the defendant. The officer observed the defendant's motor vehicle turning into a bar and initiated a traffic stop. The officer approached the motor vehicle and observed the odor of brakes and engine burning from aggressive driving. The officer observed the defendant to be the operator of the motor vehicle sitting behind the wheel and observed a strong odor of an alcoholic beverage and watery eyes. The defendant stated he was coming from Captain Tom's and standard field sobriety tests were started. The defendant then complained he had poor balance, and the defendant fumbled through his wallet trying to find his Texas driver's license and stalled when answering where he was coming from. The defendant was searched, and the officer found a receipt from a bar in the defendant's short pocket. And HEN eventually was conducted, finding 6 out of 6 clues. Walk and turn and one leg stand were refused. The D was read the DIC, but refused blood. A search warrant was obtained and executed.
Thank you, Snoopy.
All right, Mr. Durden, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to drive any vehicle that doesn't have an ignition interlock on it. That is a blow and go that you put on your car to make sure that you don't have alcohol when you get into a car. If I find that you drive a car that doesn't have one, I will put you in jail. You will not get any more PR bonds. Do you understand?
Yes, Judge.
I'm also ordering you not to consume alcohol or illegal drugs, and I will randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, you will go to jail. No more PR bonds for you, sir.
Yes, Judge.
Understand that we send notice to DPS in Austin so that any and all officers know if you get pulled over, you're to be driving a vehicle that has an interlock. And if you drive one that doesn't, they will immediately take you to jail. So be aware that the all-seeing eye knows. You understand?
Yes, Judge.
We're going to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign a reset. You will then get with Fleischer for your bond conditions, and after that, you'll be free to go. All right?
Judge.
Okay. Please.
Hey,
Hi,
guys.
Billy.
Case in Pennsylvania. I see banana bread in my future. Just a tiny car ride first.
Next is page
Yeah.
5, Flores,
Me
come on
too.
up. What do you say?
Jose Antonio Guzman Flores. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
The complainant and the defendant are in a dating relationship. On November 16th, 2024, the officer was dispatched to a residence in reference to a disturbance. The officer made contact with the complainant, who stated she and the defendant began to argue when she discovered the defendant gave her an STD. The argument began as verbal. The complainant wanted to leave, and the defendant grabbed the complainant's wrist and began to pull her. The defendant then grabbed the complainant's purse, which was wrapped around her waist, and then began to pull her hair. The complainant and the defendant separated when officers arrived. The defendant stated he did not put his hand on the complainant by grabbing her wrist, and pulling her because he wanted her to calm down. The officer observed an injury to the complainant matching her statement.
So you said pull the hair? Is that what you
He
said?
pulled her hair, yes, Your Honor.
Got it. And did you say that it hurt?
The complainant did state that she felt pain.
All right. Okay, Mr. Flores, I'm going to find that there's probable cause to go forward with the case. Do we know if she wants to have contact with him? Yay or nay?
The work was performed, let me see real quick.
Take your time. No rush. I don't see. All right, so
It does not appear she wants contact with the defendant, Your Honor.
no,
No
all right,
contact.
so, and I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Robles as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate.
Calm down. Lucy, it is you. So when you leave comments, it's a different name entirely. And I read the comment, I'm like, that's Lucy. I know that's Lucy. And it is you.
Threat or harassing behavior.
Lucy.
You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
If you violate this court order, the state can and will file additional cases against you, a violation of a protective order, and it's one of the worst misdemeanor cases you can pick up. So just stay away. Don't have contact with her. If she texts you, don't reply. If she calls you from an unknown number, hang up the phone. Just don't have any contact and everything will be fine. How old are you, sir?
22.
What do you do for a living?
Technician right now.
And what kind of money do you make a month?
Sorry.
How much money do you make a month?
$3,500 a month
And who do you live with?
with my mom.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here. We'll have you sign for the order for protection. I'll have you sign a reset with Victoria. We're going to get you out of here to hire a lawyer. After that, I'll have you take a seat while we get your bond conditions. We'll have you sign it. And after that, you'll be free to go. Okay? Come on. If you can file no contact and no weapons.
Yes, sir.
Green. Right, Judge, page 8.
You said paid 8?
Page 8.
Okay. Tatiana Green. Good morning. Ms. Green, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
The complainant and the defendant have been married for 3 years. On November 17th,
If I say I'm sick, does that increase my chance of a piece of banana bread? I'm very, very, very sick. I need banana bread to make me feel better. No, my ankles hurt. That's what happened with Nan. My ankles hurt. I'm like, Nan, my ankles hurt. 25,000 steps a day. My ankles hurt. She said, do this. I did it. It worked.
2024, officers were dispatched to a welfare check at a residence in Harris County, Texas, where the officers met with the complainant, who stated that the defendant and the complainant were having marriage issues due to the defendant cheating. The complainant stated that on November 17th, he observed the complainant laying on the couch he observed the defendant laying on the couch talking to another man on the phone. An argument then ensued. The complainant stated the defendant grabbed a curtain rod and hit him twice on the leg while he was laying in bed. The complainant stated he called 911 because he was worried about safety and needed help. Just before the officers arrived, the defendant bit the complainant's left arm, causing pain. The officer observed the injury on the complainant's arm.
Do we know if he wants to have contact with her?
I'll read the RIF, but RIF was performed, so.
Okay. Ms. Green, it looks like a protective order has been issued in this case. Get to know it. If you violate it, the state will file additional charges against you, a violation of protective order. It's one of the worst cases you can pick up. Until I
Crystal, thank you. Thank you. I'm welcome.
know that he wants to have contact with you, I'm barring you from having any contact with this person. Do you understand?
Yes, sir. So it appears that the complainant does not want contact and the complainant is moving out in order to make sure no contact.
I know.
Okay, do you have a child with this person?
No, me too.
Sir,
Great. I don't want to talk about the case.
it's not about the case. The apartment that we have together is my apartment, but right now, since I got out, I've been at my grandma's.
So for now, right, this bars you from going to the Westmead place, right? So you need a lawyer to represent you in this case. You need a lawyer to represent you in this case, ma'am. Do you work?
I do work. I just started working. Whenever I was in court
You get a lawyer for the magistration.
I didn't talk to anyone.
Okay, so what kind of money do you make a month?
Nothing right now.
How do you support yourself? Okay. Did you want to apply for a court-appointed lawyer, ma'am?
No.
The other option is you can go hire one.
No man ever bought me shoes before. And I always made more money than every single person I dated.
What would you like? Okay. Actually, I have one. So I have an affidavit already filled out. So what we'll do is I'll have you just sign a receipt with Victoria. I'll have you sign here the order for protection, and then we'll have you take a seat. Don't leave until you sign our additional bond conditions, and then we'll have you talk to a lawyer here momentarily.
Okay.
Okay, please.
It was already signed, but.
Oh, that's right. Okay, yeah, we just need to sign the reset, and then we'll have you take a seat.
All right, so next is page 13 and
Thank you,
14.
thank you.
Maple, come on up.
You are on green bond.
Yeah, I'm gonna contact no weapon.
Yes,
Love
Judge.
you long time. Maybe we'll hold ViberCon on a cruise. Do you ever think about that?
All right, Mr. Maple, I'm gonna have you take a seat in the juror box while we wait for your lawyer. Take a seat for me over there, please.
Next is page 14. Nelson, come on up.
Security, love, for the love of God. You got to know what Americans think when they read that. Barefoot, walking around in thongs. You know, that means tiny, itsy bitsy little string panties, right? And now we're all picturing you in a thong.
Same thing. I'm gonna have him wait. I mean, we're gonna have you wait. Your case is extremely old. We're gonna wait for your lawyer to get here to figure out what we're gonna do. Take a seat for me in the jury box, sir.
All right, the next is page 15.
I'm gonna need,
Pearson.
I need a second jury box. Put them on top.
My pleasure, Drunken, my pleasure.
Come on up, sir. Vic, what was the last name?
Page 15, Pearson.
Got it. Jaquan Peterson. Mr. Peterson, you're charged with reckless driving. You're facing up to 30 days and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything
Security's wearing a thong with bare feet.
you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 14th, 2024, the officer was part of a task force with the main focus being hostile street takeovers of and racers. A large group of motor vehicles were meeting at the 11700 East Freeway in a parking lot in Harris County, Texas, when the officer observed the defendant's motor vehicle enter an area of the parking lot and begin to spin his.
Si tú hablas, te pongo en la cárcel.
He's looking at me when he said that, guys. I'm sorry, Judge. I'm sorry. Put the pen down.
Okay, sorry, please.
Would you like me to start from the beginning, Judge?
Please.
Okay, but she has to wear floaties because safety first. And then jacuzzi hot tub.
Yes, Judge. On November 14th, 2024, the officer was part of a task force with the main focus being hostile street takeovers and racers. A large group of motor vehicles were meeting at the 11700 East Freeway in a parking lot when the officer observed the defendant's motor vehicle enter an area of the parking lot and begin to spin his rear tires with a loud screeching noise. The defendant's motor vehicle did several donuts, losing control of the rear end within 10 to 15 feet of other motor vehicles, making up the pit. The officer observed the defendant's motor vehicle complete approximately 2 to 3 donuts, and a traffic stop was initiated. The officer made contact with the defendant, the driver and sole occupant, and the defendant admitting to doing donuts.
Run his NCIC. Does he have any other cases like this by chance?
My
I'll
bubble
run his
butt.
NCIC, Your Honor.
Please. Mr. Pearson, I'm going to find that there's probable cause to go forward with your case. Can you imagine if you start doing these donuts, you hit and kill someone? Who gets charged with murder? These are things you must consider when you're out there in the free world. You think before you act, think before you speak, because actions may be your last.
And Your Honor, he has no other open cases or criminal history.
Do you have a Texas driver license? Do you have liability insurance in your name? Can you run his license,
It's
please?
eligible, Your Honor.
I'm ordering you as a condition of your bond not to participate in activities like this again. No reckless driving.
Okay. I'll marry you. But I demand a lot of attention. But I want you to leave me the hell alone. And that's every day. I demand a lot of attention, but I really want you to leave me the hell alone. Can you do that?
Donuts, street takeovers, racing. If I find that you do, the first thing I'm going to do is take your privilege to drive away from you. And the next thing I will do is I will put you in jail. Do you understand?
Sir.
610. The freeways, toll roads, parking lots. This isn't the right way to put. You don't do this over
might
there.
as
And I'm going
well.
to tell you now, the
might
Texas
as well,
legislature
'cause-
has made it extremely easy for DAs across.
Now my whole reputation is varnished. When I go into one of the chats, and I don't know which one it is, I got a whole big 1. It was all 0, 0, 0, 0.
Across Texas to seize and take cars for individuals who participate in these types of actions. And I've had defendants come here with their cars seized, $50,000 trucks taken because of these types of actions. So be careful out there, because not only can you next time go to jail, but you may lose that very car that you had.
Dude, where's my car?
Can you file those conditions, please? No donuts, reckless driving, et cetera. We are going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset with Victoria. After that, we will have you take a seat in the jury box while we get your bond condition. We'll have you sign it, and then you'll be free to go. When you come back, please have a lawyer, sir.
Judge Potter, page 16.
Harry Potter.
Robert Potter. Mr. Potter, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 17th, 2024, at 1:10 a.m. in the morning, officers conducted a traffic stop on the defendant's motor vehicle after observing it traveling at a high rate of speed, 67 miles per hour in a 45-mile-per-hour zone. Upon contact, the officer observed the defendant to be the driver and sole occupant and observed him with slurred speech, strong odor of an alcoholic beverage, and blood.
Robert, what did you do? You just made Victoria yell at you, and now the judge is about to admonish you.
Shot glassy eyes. The defendant admitted to drinking and scored himself as a 5 on a 1 to 10 intoxication scale. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 7 out of 8, one leg stand 2 out of 4. The officer observed the defendant to be disoriented, drowsy, had slow and sluggish reactions, was uncoordinated, unsteady, as well as disoriented during the test. An inventory search of the defendant's vehicle revealed a 12-pack of 12-ounce Modelo's in the back seat, as well as a 6-pack of 14-ounce Michelob Ultra with 1 container left. The DICs were read and the defendant consented to breath, the results being 0.097 and 0.099.
Is there any evidence that he's consuming while he's driving?
No, Your Honor.
Mr. Potter, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license? Do you have valid liability insurance?
Yes, sir.
In your name?
Yes, sir.
Are you sure? Can you run his license, please? Any priority WIs?
No, Your Honor.
I'm ordering you as a condition of your bond, Mr. Potter,
no,
not to
I
consume
love
alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any illegal drugs, unprescribed controlled medication, I will put you in jail. No more PR bonds. Do you understand?
Yes, sir.
How old are you, sir?
19.
What do you do for a living?
350.
How much money do you make a month? We're going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria, sign a reset. I'll get you with Fleischer for your bond conditions. And after that, you'll be free to go. Be careful. Don't use. I don't care what your excuse is. If I find that you're using, there's a one-way trip.
No security. I just got McDonald's and ate it while I was doing my stream. You can eat while the stream is running.
You understand? Okay, man. Come on.
All right, Judge. Next is Simmons, Irvin, page 17.
Morning, Judge.
Hi, Louise. How are you? Ms. Simmons Irvin, good morning, ma'am.
Good morning.
Ma'am, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you cannot afford a lawyer will be appointed to represent you, ma'am. Okay.
On November 14th, 2024, officers were dispatched to a trespasser call at a business in Harris County, Texas. The officers made contact with a witness who stated the defendant was asked to leave the business but was refusing to leave. The officer walked over to the defendant and tried to inform her that if she refused to leave, she would be considered trespassing. The defendant would not listen and did not want to leave. The officer attempted to detain the defendant and place her in handcuffs, but the defendant kept pulling away, refusing to give the officer her hands. The defendant also braced her legs on the ground to prevent the officer from removing her, and the officer had to use a reasonable amount of force to place the defendant in handcuffs and remove her. The defendant braced her legs against the seat and door and prevented the officer from properly detaining her in the marked unit. And once in the unit, the defendant grabbed and pulled the officer's shirt, trying to pull herself out of the unit.
Okay, what store is this that she was in?
I have the address. I'll look to see if they have a store name listed.
Your Honor, man, if I
Wait. Did she just walk up to the judge with her AirPods in her ears? What? My daughter would do that, but I didn't think anybody else would.
may speak.
Now's not the time. I mean, I've got a bunch of DAs here.
Hold on,
Anything
Judge.
that you
This
say
is
they're
my
going to use it
jam.
against you to prove guilt. You'll get the
You
opportunity, I
wanna
promise.
shoot,
Just now's not
baby?
that time. How old are you, ma'am?
I'm 30 years old.
What do you do for a living?
I don't have a job. I'm disabled.
What's the nature of your disability?
I got cardio web, a hematoma, deteriorating spine, hole in my heart, pulled over ligaments, bilateral kidneys, asthma, cancer.
How do you support yourself?
Currently at this moment, I'm supposed to be receiving, I got my social security claim number, but they refused to give me my award letter.
She had me up until bilateral kidneys. I'm gonna need some help on that one. Something I don't understand. I don't understand. Bilateral kidneys. Think that's a bad thing? That's not a good thing?
And also, I was currently supposed to be residing at Vermilion Apartments. And my contract, I guess, was switched.
I want to about the case. I just want to know how do you eat? How do you get money?
I know.
Jojo,
I need you to fill out an application for me.
I need you to fix something for me really, really, really quick. I have a knife. It's fine. I just don't want any more bilateral kidneys. I need it fixed. Can you just fix it real quick? I'll just pour some whiskey on it. Use your little knife that I give you and fix me.
And then I'll take a look to see if you qualify. As a condition of your bond, don't go back to this place.
It appears to be a housing facility.
Okay. Do not go back to this place, ma'am.
So I can't go back to Houston Housing Authority.
Whatever this place where they were trying to trespass you from, don't go back, ma'am. I'll provide you a lawyer today and we'll talk about how we go forward, but I don't want it to be more bad blood and I don't want you to go back to jail. If you go back,
it's called thong.
They don't want you there.
That's police brutality.
There's got to be some other reasonable way that we can work things out and we'll try, but you got to give it time.
I love my women when they have scalpels. Just saying.
Things cool down. If you go right back after this issue now, you're begging for trouble.
Well, my contract is supposed to be terminated on 11/30, meaning I still have an active contract. So what am I supposed to be doing about that in regards to that? I mean, I have my paperwork to prove it.
I can't give you legal advice, but we'll have you talk to a lawyer and figure out how we go forward. Okay. For the time being, don't go back though.
Okay.
Please, because it's only begging for bad blood. Okay. Yeah, so I need you to fill out an application for me. I'll have you sign a receipt of Victoria, and then we'll just have you take a seat while we find your lawyer. Okay, please.
Torres, Samuel, Ochoa Gonzalez, page 19.
So file, don't go back.
Yes,
please.
Which Gonzalez?
Ochoa.
Joe?
Sir, what is your name?
I believe you. I absolutely believe you.
Page 19.
You were Samuel Torres. Mr. Torres, you're charged with
Now that you've commented on Fozzie's wonky dinky, maybe we should have a discussion about it.
driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir. On November 14th, 2024, the officers observed the defendant's motor vehicle make a wide right turn at an intersection with a dividing concrete median, accelerate at a high rate of speed from the intersection, failed to maintain a single lane, moving halfway into the center lane before returning to the outside lane, crossed over a solid white line into a bike lane before returning to the lane, and the officer observed other cars in the area at the time, rendering the failure to maintain a single lane dangerous to the other motor vehicles. The defendant's motor vehicle stopped at a red light and remained stopped after the light turned green, obstructing traffic. And the officer then initiated a traffic stop once the defendant's motor vehicle finally proceeded through the intersection. The officers had to travel approximately 0.5 miles from the original location as the defendant continued to drive. The officer made contact with the defendant. The driver.
Should I send you a picture? Should I send you a picture? Bozzie's gonna be really mad at me.
Driver and the officer observed bloodshot eyes, an odor of an alcoholic beverage, and the defendant stated he did not immediately pull over because he lives at the apartment complex where the traffic stop was eventually performed and did not want his vehicle towed. The defendant stated he was coming from his sister's house, and the officer observed the defendant using the motor vehicle to regain balance. The defendant stated he had one Long Island liquor drink that he was currently consuming inside the motor vehicle, and the officer found a frozen daiquiri still frozen and half consumed on the passenger side of the floorboard.
He's drinking while driving?
Yes, Judge. And the officers performed standard field sobriety test, HGN 6 out of 6, walk and turn 7 out of 8, one leg stand 3 out of 4. The defendant was read the DIC, consented to breath. The results were 0.151 and 0.160.
Jeez, yes, send it over.
Mr. Torres, do you have a Texas driver license?
Yes, sir, I do.
I'm now taking away your privilege to drive. You are not allowed to drive at all for any reason. And I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. You can be facing up to 6 months in jail and a $500 fine every time you get into a car and drive. Do you understand? From now on, you'll be taking the Dodge Patas. This is an affidavit that you're going to be signing with me today, promising me. And I don't care what your excuse is. If there's a burning building with 50 kittens you have to save, you get into a car and drive, we will have issues. I'm also ordering you not to consume alcohol or illegal drugs. I will randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail. You will not get any more PR bonds, sir.
Oh no, don't you start. You send me my cheese.
Any priority to be
I'll
honest.
take care of the customs. Dodge Patas. It's my favorite saying that he does. Everybody else like stuck with like Chuck and all those other ones. Nope. Dodge Patas. You're gonna take the Dodge Patas.
How old are you, sir?
Mid-30.
What do you do for a living?
I'm a mechanic.
How much money do you make a month?
About 24 right now.
Who do you live with?
My wife, my sister, my daughter.
Who else in the house works?
Just me.
Apply for an appointed lawyer, sir. So help me. Any issue, Mr. Torres, if I set your bond $5,000 to $10,000 and you ain't got anyone to pony up that kind of money, you will be stuck like Chuck until this case is over with. Make wise decisions while you're out there, because if you don't, I'm gonna keep you. Do you understand?
Yes, sir.
Okay. Do you mind giving me an application, please? Have you application for an appointed lawyer? I need you to fill out everything. Don't just put zeros because I'm going to send it right back to you. I'll have you sign a reset with Victoria. You're going to have to meet with Fleischer for your bond conditions. Then we'll have you take a seat in the jury box.
Vasquez, Guillermo, page 20.
Do you speak English, sir?
Flores José Antonio.
Acérquese aquí al centro. Solamente mire el juez y le contesta con respeto en español.
Claro que sí. Florencio Martinez Vázquez Guillermo.
Guillermo, yes, solo mire.
Starts with driving while intoxicated.
Solo mire el juez, por favor.
You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one, sir.
Para usted, si usted no puede pagar por su propio. Solo quédese mirando el juez, por favor.
On November 17th, 2024, the officer conducted a traffic stop after observing the defendant's motor vehicle.
Why in the world did you wake up today and choose violence? Why? Why would you put a Carolina Reaper in cheese? Cheese is the opposite of hot. No, no.
Run a red light. Upon contact with the defendant,
Yeah.
who was the driver and sole occupant of the vehicle, the officer observed the defendant with bloodshot eyes and a moderate odor of an alcoholic beverage. The defendant admitted to drinking and advised that he was coming from a party. Standard field sobriety tests were performed. HGN, 6 out of 6, walk and turn, 5 out of 8, one leg stand, 2 out of 4. Inventory search of the vehicle reveals one open 12-ounce bottle of Modelo.
Drinking while driving?
DICs were read and the defendant consented to correct. The results being 0.122 and 0.126.
Mr. Vasquez Guillermo, I'm going to find that there's probable cause. Tell me, are you a United States citizen? Are you in this country with or without permission?
No, sin permiso. No, without permission.
What happens if you go to jail?
Si usted va a una cárcel. Acérquese, señor, y no me mire, por favor, solo el juez. ¿Qué pasa si usted va a una cárcel?
No, pues, no sé.
Well, I don't know.
Are you in this country with or without permission?
Sin permiso.
Yo, Kelly's about to throw down, guys. You better watch it.
Entré con permiso, me quedé.
I entered with permission, but I stayed, I remained.
If you go to jail and immigration finds you, Mr. Vasquez, they will put a detainer on you and you will be stuck in custody until this case is over with. And then you will be shipped off to immigration where you will sit for another 6 to 9 months waiting for immigration to do whatever they're going to do. I would hope that you recognize it's elementary that you're not to have alcohol in the car while you're driving. And it is a minimum of 5 days in jail to any sentence you get if they allege the open container. I will tell you now that immigration sweeps it every single day. So if you spend more than 6 hours in custody, you'll be stuck like Chuck with an immigration detainer. I'm now putting conditions on your bond. And if I find that you violate these conditions, you will go to jail in a moment's notice. And I don't care if you're kicking and screaming.
Your jokes
Do
are
you
awesome,
understand?
Tokyo.
Señor? Sí, señor o no, señor?
Sí, 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 entiendo.
You are not allowed to drive. And you will be signing with me today a promise that you're not going to drive. I don't care what your excuse is. If I find that you drive, to jail you will go. Likewise, I'm ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If you test positive for alcohol or drugs, likewise, you will go into jail.
De igual manera la va a ir a una cárcel. That's fine, that's fine.
Any priority to be eyes?
No, Your Honor.
Ninguno. Solo el juez, por favor. Entienda eso.
Sí.
We are going to reset your case to give you time to hire a lawyer. So I will have you come up here, swear to us that you're not going to drive. This is an affidavit. I'm going to tell you now, Mr.
Swear,
Vasquez,
Judge.
look at me.
Míreme.
This is the only warning you will get from me. One violation whatsoever. I'm going to keep you with me.
Mantenerlo usted conmigo.
Do you understand?
¿Entendió eso, señor?
Sí, señor.
Yes, sir.
Okay, coming up here, swear to us that you're not to drive. We'll get you to Victoria and then we'll get you with Fleischer for your bond condition.
Casey Carey, are you Naruto?
Alright, Judge, next is page.
Oh wait, he's Hokage, not ninja. My bad.
Good morning, Ms. White. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a
I'll
$4,000
fight
fine.
them for it.
We're
Give me
going to
my
do probable
cheese.
cause. You have the right to
know who
remain
I am.
silent.
I know the
Anything you say
mayor.
can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. The complainant and the defendant are married. On November 16th, the officer was dispatched to a residence in Harris County, Texas, in reference to an assault. The officer met with the complainant, who stated the defendant and him had a verbal altercation that began the night prior, due to the defendant thinking the complainant was talking to another woman on the phone. The complainant stated he tried to sleep, but the defendant wouldn't stop arguing. The complainant stated that he slept in a separate bedroom, but the defendant came into the bedroom at 5 a.m. and started yelling at him, accusing him of cheating. The complainant stated he tried to walk out when the defendant struck him with a closed fist right between his eyes, causing him to feel pain and discomfort. The complainant stated he feared for his life and had no other choice but to call 911.
Okay, Ms. White, I'm gonna find that there's probable cause to go forward with the case. Do we know if he wants to have contact with her?
Let me see if a rip has been done, Your Honor.
Please.
No rip has been done, Your Honor.
Okay. I don't know if he wants to have contact.
That's kind of personal. I mean, it's clearly One Piece. Absolutely One Piece. Luffy is the greatest character ever made. Awesome. But Meliodas is pretty good from Seven Deadly Sins. I like him. And I do. And Urza is outstanding from Fairy Tales. How can you ask what our favorite anime is? That's rude. Like that'll take me an hour to One Piece. It has to be because Luffy. Digimon. I love Digimon. Luffy. One Piece. It's easy. Luffy. One Piece.
Contact with you. So until I know, I'm ordering you not to have contact with this person. A protective order has been issued in this case. I would suggest you get to know it, because if you violate the protective order, the state can and will file additional charges against you, a violation of a protective order, and it's one of the worst cases that you can pick up. Do you understand, man? So you're not to have contact with this person and not to be.
That's like a cheating. That's like, what's your favorite pizza? Oh, cheese. You can't pick Sailor Moon. Okay, the question should have been, Kelly, what's your favorite anime except for Sailor Moon?
Possession of weapons. Do you work, man?
I do.
What do you do for a living?
I'm school bus driver.
What kind of money do you make a month?
3,000 a month.
Okay, we're gonna reset your case to give you time to hire a lawyer. I'll have you go to Victoria, sign a reset. After that, we'll just have you take a seat in the jury box, so we'll get your bond finished, you'll have you sign it, and then you'll be free to go, man. Okay?
No one said My Hero
Please.
Academia, which
So
made me
no
happy.
contact, no weapons. Please.
Oh my gosh, Snoopy, you ruined it. He cries all the time. Oh my, I'm so sorry. Oh my, I'm not you. I'm trying. Vampire Hunter for the win.
Judge, that was the last.
You had one that had picked up another DWI.
Yes.
Where is your client?
He was sitting in the ERD because his prior case was
Still
ERD. He thought
cheating.
he's here now.
Okay, can you bring him up, please? You speak English?
Yes, sir. Adiós, gracias.
Oh my, no, my, I'm so sorry.
No. It was DWIs.
Oh, that was good.
Yeah.
Haiku. Love Haiku. Oh God, what's that one? Oh, I love it. Oh, come on, the countries: Italy, United States, Alfred F. Jones. Oh my gosh, ha 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 ha. Starts with an H. It's really good, and I can't remember the name. No. Yeah, you can pick Naruto. That's almost cheating, but it's okay. It's good enough.
Yeah. What's the word with him?
Boruto. Dragon Ball Z. No.
Can you bring him up and put him in the, I don't want to lose him. Please. Joshua Jones, come up. Is there space? You are
Natalia.
Aziel Gracia.
Natalia.
Mr. Gracia, you. So
He's charged with, I've never seen this before, Judge, but he's charged with violating a bond condition.
Oh, yes.
yeah, I mean, I've certainly seen it.
And
It's either
It's not a protective order, it's a bond condition.
right because they can't make the protective order case because it's been more than 61 days, right?
Nothing to do with the protective order, Judge.
So yeah, right. I get it.
It was a different situation completely. Had nothing to do with family violence.
Get there. So you're charged in violation of a bond condition / protective order. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. If you cannot afford a lawyer be appointed to represent you. So before we start, was he in a PTI? Is that why this case is 1,000 days old?
Yes, sir. He just has a few BIP classes left to finish the PTI.
Okay. Okay, go for it.
The officer was dispatched to a business in Harris County, Texas, in response to a disturbance. Upon arrival, the officer observed the defendant grab another male aggressively, and the officer.
My Hero Academia rolls when you want to cry. I'm so sorry. I tried so hard. That's the whole anime.
Conducted a search on the defendant's person and found a loaded gun in the front pocket. The defendant is currently on bond for an assault family violence and has bond conditions in place prohibiting from possessing a firearm.
Yeah, all right. Mr. Gracia, I'm gonna find that there's probable cause to go forward on the bond conditions.
I'm happy.
State, what's your position as far as he's in a PTI? He's now picked up a new case. Mr. Gracia, I want you to know that we take these bond conditions extremely serious.
Sure.
You don't, though. This is not your first VPO. This is not your first violation of bond condition. You don't get it. No means no. Doesn't mean maybe. Doesn't mean I'm going to a high crime area. No means no. And now there are consequences. Stephen.
I don't even know if I
Can I
still
tell you
have
a little bit
friendship.
about the case?
Sure.
You know, like, just to explain to you what happened. He was at his business. He owns a trucking company. He hired somebody who he said he took a chance on him because he's has a sketchy record, convicted felon. It didn't work out within a couple of days, so he ended up firing the individual. The individual refused to leave the premises or refused to accept it. So he started threatening him. He went inside. The individual started trying to damage the trucks. So at that point, he was fearful. He went and retrieved a firearm that he knew was hidden in the vehicle. I'm sorry, in there. I understand, Judge. And
it's about the worst thing that you can do. Imagine if you use the firearm. Who gets charged with murder?
Okay, they said Sailor Moon, Judge, but take it down. They'll change their mind as soon as they watch a few other ones.
Mr. Gracia, who has now dug themselves into a potential 50-year hole. We have a case like that today where a meager argument, someone who's charged with assault is now charged with murder because of a silly ass, stupid ass argument. Now, dude is sitting in custody with a $250,000.
And he's been punished at this point, Judge. He's been punished for violating the bond by getting an entire new case on that. So as far as him going into custody for violating the bond condition, I would hope that you would take that into consideration, the fact that he has gotten punished on the bond violation already.
Yeah.
And the fact that he's already had to hire a new attorney for two cases at this point, and it's probably going to affect the other case. So I would hope that you would continue supervision on that, just taking that into consideration.
I truly appreciate your position, but you have an assault from 2019 of a family member. The following year, you pick up a violation of a protective order or bond condition. Now you have another assault that they were even, what the hell are you looking over there? Was it Jesus over there?
Bye, Michael.
You already have an assault of a family member that was dismissed as it is. You were lucky enough to even have this kind of an agreement where they're willing to dismiss a second assault of a family member. And now you pick up another violation of a bond condition. Eric, he doesn't get it.
I understand, Judge.
You don't get it. And now
Fairy tale.
I have to show you,
Lucy and
we
her
mean
keys.
business. I think that you are
Where's
utter
that?
and complete danger to public safety. And I will do everything in my power to protect my public in every single way. Because the last thing I want is you to pick up a murder case like we have here this morning. Someone else goes with you.
Judge, one more thing. There's a bond condition on there that he's not allowed to return to that address. That address is his business. It's his place of business. The other person has no right to that address. So hasn't worked for the last week and a half because there's a bond condition, I'm assuming from the magistrate, that doesn't allow him to go back to that business.
Show me proof.
I'd like to be
Show
able
me
to take that.
proof. And, you know, the proper, you know, and you need advice, the proper way to do things is you call the cops.
Get a judge.
Really. I mean, that's, if you own the business, you show it. I mean, how easy would it have been to just call police?
I mean, he has a right to defend his property and. his-
Not while the case is open. He does, but not in that manner.
It's one of those things where things happen quick and you have to make a decision. And when we're talking about trucks that are worth hundreds of thousands of dollars, and things like that.
911, man, really?
How long do they take to get there, Judge? So he's-
Okay, they will still take his ass to jail and then, you know, try to get restitution or whatnot, but
So as far as the bond goes, can you set him a bond today? So
of course.
And Judge, we've contacted Conrad because it's his case, but I just want to confirm that bond has been revoked for his prior case. Is that correct?
Yeah,
Okay.
yeah, on the assault, I'm revoking it.
Yes, Judge.
Looks like they set the bond at 20,000 on the new case.
Yes, Judge.
I'm gonna mirror it.
Because he's already posted that bond, he's already hired me. He hired me on the other case as well. There's a motion to sub in your queue that I need you to sign as well.
I'll sign it for you.
I'd ask that you set that new bond at $500. It's tough for the family, Judge. I mean, at this point, he hasn't worked in 2 weeks. He's trying to get back on his feet. He did everything properly. He didn't go back to the location because of the bond condition.
I'm not doing $500. I mean, I was thinking that was gonna mirror the same one. I was gonna put it at
And that would be a
20,000.
state's position to mirror.
So he understands that we mean business, you know, if he's unable to bond out, I'm always willing to talk after a couple days, you know, but I want him to understand that we take it absolutely serious. And when you go over there with a gun with the intent to do some serious damage, hell no, no way, no. And I think that making it 20,000, what the other one is, hopefully it'll get his attention. But like I said, look,
10,000?
like I'm not out for blood, Eric, you know, so if he's unable to, after some time, come back, and I'm not talking weeks, but you know, a couple days, so he realizes that we mean business.
So we're talking about 2 weeks minimum. So would you consider giving 10,000?
Well, remember, I Zoom, so you can be in Abu Dhabi. I'm still, well, here.
His mom's present, so let me talk.
Yeah, for sure. Okay. 20
Sorry,
Gs.
Tokyo, but when you come back in 30 to 40 minutes, you'll be alone. But I love you. Guys, thank you so much for coming out today. And we finally got to the verdict from the guy. You don't even know who I am. You don't know who I am. I know the mayor. Oh. Maybe she has both. Maybe Linus has a sister and a brother. Anime made me lose track of time, and now the stream went for 2.5 hours. I do love anime though. I don't like subtitles. I mean, I don't like dubbed. I don't like dubbed. I like subtitles. Sub, not dubbed, because no one gets the voice acting right. I mean, did you hear Luffy on Netflix? No, I couldn't even watch it. Bye, guys. Thank you so much for coming out. I really, really, really appreciate it. I shall see you guys in 24 hours because there ain't no court today. Yeah, go get some sleep. And go watch an anime, guys. Good. Not Sailor Moon. Bye, guys. See ya. Thank you.
Got this life that goes digital dreams through the screen. lights the way. Her eyes near a sky so blue. In her jokes there's a truth so true. With extreme she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted sharp, in a way there's no alarm. Streaming tales late into the night, her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh